Hey there, welcome back to our channel. Today, we've got a fascinating topic to dive into: cross-border insolvency and the intriguing concept of the Center of Main Interest, or COMI. It's a legal puzzle that plays a crucial role in deciding where insolvency proceedings for a company should take place, especially in the rapidly evolving world of digital economy groups. So, let's get started. What is cross-border insolvency? First off, let's break down cross-border insolvency. It's when a company has assets or debts in more than one country, making the whole insolvency process a lot more complex. Imagine a tech giant with offices and investments all over the globe. That's where the real fun begins. Cross-border insolvency refers to a scenario in which a corporate debtor possesses assets or has financial obligations in foreign countries, distinct from the nation where it was originally incorporated. In such cases, not only are domestic insolvency laws applicable, but the laws of the foreign country where these assets or liabilities exist may also have a role to play to some extent. The concept of cross-border insolvency emerged through the efforts of United Nations Commission on International Trade Law, which introduced a model law on cross-border insolvency in 1997. This model law aimed to assist nations in managing corporate insolvency and financial distress cases involving companies with interests in more than one country. Its primary objective was to encourage collaboration between the courts and relevant authorities in foreign states when dealing with cross-border insolvency situations. COMI, the Center of Main Interest. Now, let's introduce the meaning of Center of Main Interest, or COMI. In cross-border insolvency, COMI decides where the insolvency resolution takes place. It's essentially the place where the company does most of its important stuff, like decision-making and admin work. Think of it as the company's heart and soul, but in a legal context. Insolvency models demystified. Universality versus territoriality. Universality model. Our first contender is the universality model. It argues that when a debtor faces insolvency, all their assets, no matter where they are on the globe, should be bundled together into one big estate. This estate would then be subject to the laws and regulations of the debtor's home jurisdiction. It's like a one-size-fits-all approach to insolvency. Territoriality model. Now, let's meet the territoriality model, the opposing champ. This model says, hold on a minute. Insolvency proceedings should only apply within the borders of the country where they were initiated. In other words, the reach of insolvency proceedings is limited to the territory of the initiating jurisdiction. So, what happens when these two models clash? That's where COMI, or the Center of Main Interest, comes into play. It's like the mediator between universality and territoriality. COMI helps prevent conflicts between different courts by determining the primary jurisdiction in cross-border insolvency cases. COMI considers where the debtor is based, where they make important decisions, and where their central administration happens. It's all about finding a middle ground to ensure fairness and efficiency in cross-border insolvency proceedings. The European Union, EU, was a pioneer in adopting the Center of Main Interest principle, incorporating it into the European Insolvency Regulation in 2000, which came into effect in 2002. Throughout the years, the European Court of Justice and courts across EU member countries have significantly contributed to shaping and refining this concept. Now let's talk about the evolution of COMI principle in European insolvency law. EU nations like Luxembourg and Ireland, known for their attractive tax incentives, have become preferred locations for companies to establish their corporate headquarters. In response to this, the EU has taken an active role in enhancing the effectiveness of cross-border insolvency procedures. They have provided greater clarity and expanded upon various key aspects of this field, including the COMI concept. In 2017, the EIR 2000 underwent revisions that elaborated commented extensively on COMI-related matters. In the landmark case of Ray Eurofoods, the European Court of Justice (ECJ) established that by default, COMI is presumed to be the jurisdiction where the debtor maintains their registered corporate office. However, this presumption can be challenged if evidence is presented showing that the registered office is merely a symbolic address and the company's administration and most economic activities occur elsewhere. Furthermore, the ECJ ruled that the responsibility for determining COMI falls on the courts where insolvency proceedings are initiated. The court in the original jurisdiction must initially assess whether the debtor's COMI resides within its territory based on the available evidence. If this court concludes that COMI is indeed in its jurisdiction, other courts where parallel insolvency proceedings are initiated against the same debtor must recognize the original jurisdiction's proceedings as the main proceedings. If a court in another jurisdiction believes there is an error in the original jurisdiction's decision, it may appeal to a higher court in that jurisdiction. The Eurofoods case decision underscores the potential for forum shopping by companies seeking lenient regulations for administration and liquidation. It emphasizes that the court must go beyond the mere presence of a corporate office in a jurisdiction and actively determine whether the registered office actively contributes to the company's administration. Additionally, European jurisprudence regarding COMI places significant importance on the opinions of the debtor's creditors in identifying the principal place of business. Factors such as the nationality of the company's directors and the jurisdiction where the company's board meetings are regularly held also carry weight in determining COMI. Now let's look into the Indian angle and study the cases of Jet Airways Limited versus State Bank of India and ANR in. Picture this: Jet Airways in financial turmoil and insolvency proceedings are initiated in the Netherlands. The Dutch side decides to knock on India's door seeking recognition of their proceedings. But India's National Company Law Tribunal slams the door shut, saying Indian law has no provision for recognizing foreign proceedings. But wait, here comes the twist. The National Company Law Appellate Tribunal takes a different stance. They pull out the model law playbook, which deals with cross-border insolvency and makes a crucial determination. They say, yes, Jet Airways has assets in the Netherlands, but its center of main interest is in India. Now, you might be wondering, what's COMI? It stands for Center of Main Interest and plays a pivotal role in cross-border insolvency. NCLAT decides that since Jet Airways' registered office is in India and most of its admin happens there, India is its COMI. Here's where it gets interesting. NCLAT doesn't fully recognize the Dutch proceedings but labels them as non-main foreign proceedings. They tell the resolution professional in India to team up and cooperate with their Dutch counterpart. They even set the terms for this cooperation in a special agreement. So, there you have it. A roller coaster ride through Jet Airways' cross-border insolvency saga. The lesson here: cross-border insolvency is a maze of legal intricacies, and even within the same legal system, different courts can have different takes on it. India implemented the Insolvency and Bankruptcy Code in 2016, marking a significant milestone in its legal landscape. Since then, the IBC has undergone a series of changes through legislative amendments and judicial interpretations. However, it's noteworthy that the aspect of cross-border insolvency was initially left unaddressed. It's only in recent times that dedicated committees, namely the Insolvency Law Committee and the Cross-Border Insolvency Rules/Regulations Committee, have taken proactive steps to introduce cross-border insolvency laws and integrate them into the existing framework of the Insolvency and Bankruptcy Code. In the context of cross-border insolvency proceedings in India, questions naturally arise, such as how the center of main interest is determined, what factors influence this determination, and what role COMI plays in the overall process. These are crucial considerations as India adapts to the challenges and complexities of cross-border insolvency cases. In the proposed draft Chapter Z of the Insolvency and Bankruptcy Code in India, Clause 14 introduced the intriguing concept of the Center of Main Interest or COMI into Indian law. It's clear that the Insolvency Law Committee has taken inspiration from the European Union's interpretation of COMI, and we can see this in clauses 14 subsection 2 and 14 subsection 3. Clause 14 subsection subsection 2 lays down a rule that COMI jurisdiction, presumed to be where the debtor's registered office is located, will only be in effect if the office hasn't changed its address within 3 months from the start of insolvency proceedings. This bears a striking resemblance to Article 3 of the European Insolvency Regulation (EIR) from 2017. Moving on to Clause 14, subsection 3, it introduces a pivotal shift by placing the responsibility on India's adjudicating authority to determine a debtor's COMI. This determination will be based on specific factors that will be defined by the central government. Here again, we can see the influence of the EU's approach. In a sense, India's draft Chapter Z brings the COMI concept into the Indian legal landscape, showing a certain alignment with the EU's interpretation. Legal concepts, it seems, have a way of transcending borders and finding common ground. Now let's talk about COMI, the most trickiest part. Now, here's where it gets tricky. When a company's cross-border insolvency is on the table, we need to figure out its COMI. The big question here is, what date should we consider for determining COMI, and what factors should be taken into account? Different jurisdictions have different ideas about when to pinpoint COMI. Should it be when the foreign insolvency proceedings begun, when the recognition application was filed, or something else entirely? It's a bit of a puzzle. Then comes the factors that help us determine COMI. Some say the registered office should be the starting point, while others argue that an identifiable place of central administration is the key. It's like putting together a jigsaw puzzle, but with legal pieces. Let's talk about important cases. Let's not forget about real-life examples. The Zeta Jet and Jet Airways cases are perfect illustrations of how COMI determination can make or break cross-border insolvency proceedings. The decisions made in these cases set important precedents. As India and other countries venture further into the realm of cross-border insolvency, it's clear that uniformity and certainty in the insolvency resolution mechanism are essential. It's all about ensuring a speedy and efficient resolution of corporate insolvencies with international dimensions. So, there you have it. Cross-border insolvency and the enigmatic COMI are shaping the future of bankruptcy laws in the digital age. It's a complex puzzle, but as countries work together to crack it, we can expect smoother insolvency proceedings in our ever-connected world. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights. Thanks for tuning in, and we'll see you in the next video.